There is a war going on in this country between the defenders of the traditional American regime and the woke revolutionaries who seek to implement a new regime, the group quota regime, whose false understanding of justice hinges on the fantasy of outcome equality. Success relies on seizing power by co-opting democratic channels. Left-wing attempts to silence those alleging irregularities post-2020 election. The 65 Project aims to smear and intimidate lawyers assisting President Trump. Dr. Eastman, a scholar and wife of the 65 Project target John Eastman, argues that this harassment campaign will not only result in the political persecution of conservatives, but also in the erosion of constitutional order, the abrogation of the historic right to representation, and the destruction of the adversarial system upon which our legal practice and our rights depend. These are the stakes, and opponents of the group quota regime must appreciate their gravity if they hope to mount a serious political response. American Constitution ensures right to counsel for defense, protected by various amendments. What, however, are the implications when the lawyers who provide that defense are threatened with disbarment proceedings, crushing legal costs to defend their licenses, exclusion from participation in the broader legal and academic communities, and having their reputations smeared, all because they represented clients who were deemed unpopular or took on cases fraught with controversy? Lawyers throughout America are being subjected to these very ordeals due to their participation in cases related to the 2020 presidential election. One of the principal groups pursuing this strategy operates under the name the 65 Project. The group targets lawyers who litigated 2020 election irregularities or represented President Donald Trump. It does this by filing complaints against them in state bar associations, contending not only that the lawsuits were meritless, but that anyone involved in them should be sanctioned up to and including disbarment. This may be the first time in our nation's history that election controversies have devolved into such lawfare. Election controversies are not uncommon, and heretofore they have not led to such actions by disciplinary bodies. Legal challenges in past elections, fraud uncovered, new elections ordered, integrity fundamental for legitimacy, voting ensures sovereign authority. Project aims to deter election challenges, strikes at legal traditions. The actions of groups like the 65 Project diminish and compromise the bar associations, the legal profession, the adversarial system, and the country. We are witnessing a shift in the legal system, from lawyers representing and defending clients to lawyers becoming the accused and, as a form of pseudo-juridical destruction, being charged with unfounded claims. If we do not put a lid back on this Pandora's box, controversial clients will not have the benefit of representation, disputed issues will not get a hearing, constitutional issues will remain unresolved, the legal system will lose worthy advocates, and due process will be effectively thrown out. Lawyers facing frivolous bar complaints should be financially supported and defended by peers. Allegations of irregularities in elections should be thoroughly investigated and resolved in courts. Forcefully repudiate the efforts of the 65 Project targeting lawyers and election claims.